The disrespect that y'all are showing to the officers, I can assume what these are going to say. I will not accept this plea agreement. I'm sick of it. The jail's sick of it. Thank you, Ms. Malfino. All right, sir, are you Camden Jackson? And Mr. Harris, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Give me just a second to get it done. Mr. Jackson, in
Right away, the defendant enters a guilty plea to engaging in organized criminal activity, a second-degree felony. But here's the important part. The judge isn't simply rubber stamping a deal. The proposed outcome is 7 years of deferred probation, meaning the defendant could avoid an immediate prison sentence if the court approves the arrangement and the conditions are successfully followed. And that if is about to become very important.
cause number 20. All right, y'all marked third degree on the paperwork, but the indictment says second. I just want to make sure it's the mark correctly.
Yes, I just looked at it sideways.
Okay, so that should be second degree.
Yes, Your Honor.
If everybody's permission, I'll make that change on the paperwork.
Yes.
Okay.
And apologies for my handwriting because it's horrible.
Well, it's hard on the tablet. You're good. All right, so you're charged in cause number 25 DCCR 0114 with the second degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely?
The judge has now found the plea voluntary, the defendant competent, and the evidence sufficient. But sentencing is being delayed. Why? A pre-sentence investigation, or PSI, gives the court additional information before deciding what sentence or probation conditions are appropriate. In other words, the plea is accepted, but the final outcome isn't completely settled yet. The judge wants more information before making the big decision.
And voluntarily.
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment, like ISF or something like that. And it looks.
And now the defense is essentially asking for a warning shot. Give him a chance, but make it clear that bad behavior while he's waiting for sentencing could change everything. The problem? The court is already hearing about multiple jail incident reports. So the question becomes brutally simple. Can someone convince the judge they're ready for probation while they're still struggling to follow rules inside the jail?
It's like that's what the state's going to be requesting. Do you understand? And that decision's up to me when we come back for sentencing. Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea.
This is where the proposed plea deal suddenly looks a lot less secure. The judge has discretion over whether to accept the negotiated recommendation, and she's making it clear that jail conduct can influence how she views the defendant at sentencing. The message is unmistakable. Probation isn't guaranteed just because the paperwork says 7 years deferred.
Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Before we go forward, can you look real quick jail incident reports and see if there's any on this one?
And Judge, I was, if I may, going to address that between January and the end of February. So obviously we've had quite some time that either they have not gotten to my file or the court's file. There were at least 8 pages full of write-ups. I would ask the court, Mr. Jackson committed this offense 6 days after he turned 19. It's obviously very serious. He was with the co-defendant, Mr. Bushnell, who's already entered a plea involving firearms, etc. I would ask if the court would consider your usual admonishment.
That is a serious ultimatum. The judge is basically putting the next few weeks under a microscope. One more incident could jeopardize the deal. And notice the broader concern. She isn't only talking about punishment. She's talking about the officers and staff who have to maintain order inside the jail. This has gone from follow the rules to a direct test of whether the defendant can demonstrate the behavior expected on probation.
If that behavior continues pending the PSI, that I reserve the right, as does the court, to just reject this offer and possibly send him to prison.
Mr. Jackson, you're probably, I don't know if you're in the same dorm as some of the other ones that have been
Yes.
absolutely ridiculous acting up in the jail. So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect that y'all are showing to the officers, I can assume what these are going to say, because y'all are all out there. It's the same group that's doing all the same thing, fighting, not following instructions, talking back, calling names. I'm going to read all of that. And let me tell you, if you have one.
And that's the judge's challenge in one sentence. Show me, don't tell me. 5 weeks of staying out of trouble may sound small compared with the consequences of losing a probation recommendation, but that's exactly the point. The court is giving him a very clear opportunity to prove he can follow basic conditions. Now the countdown begins, and every incident, or lack of one, could matter when he returns for sentencing.
One, between right now and your sentencing, I will not accept this plea agreement. I'm sick of it, the jail's sick of it, and I'm going to do whatever I can to make that place a better place for those people to go work who are out there just trying to do their job. Do you understand? One, we're not going to come in and say it was somebody else's fault, I only got one, or I got three, and that's not that bad. You can go out there and tell them, I want to get out and be on probation. I don't care what you guys want to do. I'm going to behave. If you have to sit on your bunk all day long and be quiet for the next 5 weeks, then that's what you do. Right? 5 weeks, rest of your life. What do you think? Show me you can do it, okay? All right, and go back with the bailiff.
Thank you, Your Honor.
Yes, sir.